This is the case that changed everything about how fast an administration can shrink an agency. What happened in that courtroom would send shockwaves through student aid offices. It would also shake civil rights enforcement and the balance of power itself. One unsigned order and a national fight moved into a new phase. Welcome to Gavel Files, where justice tells its story. Today we examine the case of New York versus McMahon. It is a civil clash with constitutional echoes, and it asks who controls the machinery of government. According to court documents, the plaintiffs were the state of New York and other states. They were joined by school districts and unions. They argued the Department of Education was being dismantled in practice. They said Congress created that department for a reason. They warned that mass layoffs could hollow out statutory duties. On the other side stood Linda McMahon, the United States Secretary of Education. She led the administration's plan to reduce the department workforce. The goal, the government said, was efficiency and accountability. It also aimed to return control to states. The defense maintained that management choices belong to the executive branch. Court documents reveal the flashpoint date was March 11, 2025. That day, the Department of Education announced a reduction in force. The number was 1,378 employees. That was not a trimming at the edges. Plaintiffs called it a cut to the bone. The plaintiffs focused on programs that depend on staffing. Student loans require processing, oversight, and enforcement. Civil rights complaints require investigations and monitoring. Higher education certification requires review and compliance work. The evidence showed these tasks do not complete themselves. The government framed the same facts differently. It described layers of bureaucracy and duplicated functions. It said streamlining would not end legal duties. It said technology and reorganization could cover gaps. Secretary McMahon promised resources would reach students, parents, and teachers. But the lawsuit was not about policy preferences alone. It was about lawful authority. Plaintiffs argued the executive cannot erase statutes through staffing decisions. They said firing the people who carry out the law defeats Congress. They warned of a separation of powers crisis. This case rose on that tension. The incident that triggered legal action was not a single scandal. It was the administrative act itself and its scope. States and unions said the reduction in force was unprecedented. They said it would cause immediate disruption. They claimed the harm would be irreparable. They went to federal court for emergency relief. They filed in the United States District Court in Massachusetts. The presiding judge was Myong Jun. The plaintiffs asked for an injunction to stop the layoffs. They also sought reinstatement of employees already terminated. They wanted the court to block shifting programs elsewhere. They argued the department would become a shell. Prosecutors argued that the reduction in force exceeded executive authority. In civil terms, they claimed it violated statutes governing education programs. They emphasized duties Congress imposed on the department. They said the department could not meet those duties with half a staff. And they said the harm would fall on vulnerable students first. The defense maintained that courts should not micromanage agency staffing. It argued the executive can restructure to carry out policy goals. It said the plaintiffs were speculating about future harms. It also argued that internal reallocations could keep services running. The government asked the court to stand back. The judge ruled in a way that stunned the administration. On May 22nd, he issued an injunction blocking the layoffs. He ordered the department to reinstate affected employees. He found the reduction made it effectively impossible to fulfill obligations. That phrase would become a central battleground. It was a judicial finding with teeth. But injunctions invite counterattacks. The government sought emergency relief. It went to the United States Supreme Court. It asked for a stay of the injunction. It said the district court had overreached. It said the executive branch would be hamstrung. But what happened next would change everything. The emergency application framed the question as urgent. The Solicitor General, D. John Sauer, argued for immediate intervention. He said the injunction forced the government to keep employees it chose to release. He described the order as interference with management. He argued the plaintiffs could litigate without blocking the plan. The government insisted the balance favored a stay. The plaintiffs answered with their own urgency. They said the layoffs would break essential functions. They said student aid would slow and errors would rise. They warned civil rights investigations would stall. They said the workforce cuts were the point, not a side effect. They argued the court should prevent a fait accompli. Court documents revealed the Supreme Court did not hold full argument. The justices considered the stay request on the papers. There was no public hearing to absorb the stakes. The country waited for a short order, and the order came like a gavel strike in the dark. The Supreme Court issued a brief unsigned order. It stayed Judge Jones' injunction. It allowed the reduction in force to proceed. It paused the reinstatement requirement. The effect was immediate and concrete. Nearly 1,400 jobs could vanish while litigation continued. One justice did not let it pass quietly. Justice Sonia Sotomayor wrote a lengthy dissent. Justices Elena Kagan and Ketanji Brown Jackson joined her. According to court documents, the dissent ran 19 pages. She called the majority decision indefensible. She warned it threatened separation of powers. She wrote that the ruling hands the executive power to repeal statutes, not by voting, but by firing those needed to carry them out. She warned students would pay the price. She highlighted discrimination complaints and aid disruptions. She accused the court of willful blindness or naivete. The dissent read like an alarm bell. Drop a comment. Do you think the verdict was fair? And then the prosecution revealed their key evidence. The evidence showed the March 11th announcement in plain language. It described the scale and timing of the reduction in force. Plaintiffs used it to show intent and magnitude. They argued it was not a modest efficiency plan. They said it was a structural dismantling. They pointed to the raw number of positions. Next came the district judge's findings. The judge ruled the cuts made compliance effectively impossible. Plaintiffs treated that as a factual anchor. They argued courts defer to factual findings at this stage. They said the injunction protected the status quo. They said the Supreme Court should not disrupt it. Then came the government's own public statements. Secretary McMahon said the reduction would promote efficiency. She said accountability would improve. She said resources would go where they matter most. The government treated those statements as policy justification. Plaintiffs treated them as proof of an ideological goal. Both sides used the same words differently. If this case is gripping you, hit that like button. The defense strategy focused on authority and timing. The defense maintained that plaintiffs were using courts to freeze the executive. It argued that staffing levels are not statutory commands. It said the department can meet duties with different structures. It emphasized that the case remained pending below. It asked the court to prevent premature judicial control. The government also leaned on the emergency posture. It argued a stay preserves flexibility while courts decide merits. It said reinstating employees creates chaos and costs. It said the injunction forced immediate reversals. It argued that the public interest favored efficient administration. It framed the plaintiffs as political opponents using litigation. Plaintiffs responded by returning to practical consequences. They said the department is not an abstraction. It is people processing forms and investigating complaints. They said delays in aid can derail enrollment. They said civil rights delays can expose students to continuing harm. They said the law's promises require manpower. They framed the layoffs as the injury itself. The jury had heard enough. But they were not ready for this. There was no jury in this Supreme Court moment. But the deliberations still carried drama. The justices weighed emergency standards and institutional boundaries. They weighed deference against judicial oversight. They weighed immediate harm against long-term authority, and they did so behind closed doors. Then the order arrived and the balance shifted. After deliberation, the foreman stood up. In this case, the foreman was the court's unsigned majority. The verdict was procedural, but powerful. The Supreme Court stayed the injunction. That meant the administration could proceed with layoffs. It meant reinstatement was paused. It meant the plaintiffs lost their immediate shield. It did not end the lawsuit, but it changed the terrain. Inside the legal world, reactions split sharply. Supporters called it a correction of judicial overreach. Critics called it a green light for dismantling by attrition. The dissent drew headlines and intense debate. The unsigned order drew criticism for its silence, and the department moved forward with its plan. There was no sentencing in the criminal sense. No prison time applied. No fines were imposed. But consequences landed like punishment for those affected. Jobs were cut, offices reorganized, and workloads redistributed. Programs faced uncertainty as staffing changed. The underlying case continued in lower courts. Appeals remained part of the story. Legally, the impact reached beyond education. The stay suggested courts may hesitate to block mass restructurings early. It signaled deference to executive management during litigation. It also raised fears of statutes undermined through staffing. Future administrations could cite this moment. Other agencies could become targets of similar reductions. The separation of powers debate grew sharper. Where are they now? The plaintiff states, districts, and unions kept litigating. They continued advocating for federal education protections. They sought to prove concrete harms as the case progressed. Secretary McMahon implemented the reduction in force. The department shrank by nearly half. Duties shifted towards states as planned. The New York versus McMahon reminds us that justice is never simple. Share this video with someone who cares about justice. Drop a comment with your verdict. Guilty or not guilty? Hit like and subscribe to Gavel Files for more cases where justice tells its story. Next week, we examine another case that shook the nation.